Getting assaulted.
Yeah, by one of their workers.
What happened?
I was just out here taking some pictures, and one of the guys came out here saying he didn't want to be filmed, and he ran up to me, started searching.
Welcome to U.S. Corrupt Cops, your go-to channel for uncovering the truth behind law enforcement misconduct. In today's episode, corrupt cops get instant karma. What happened next? We'll explore some jaw-dropping cases where corrupt officers faced immediate consequences for their actions. If you like this video, press 1. On September 9th, 2022, First Amendment Auditor Joshua Roberts, the owner of the Pepperoni Audits YouTube channel, was filming outside Dove Technologies in Florence, South Carolina, when two employees exited the building and approached him as he continued to record.
You don't have my permission, you can turn that off right now. Have my face.
What was that? I can't hear you.
You don't have my signed authorization to have my face in that camera, turn it off.
Can I have your signed authorization? This guy's coming up aggressive, everyone. Can I help you?
No, can you help us?
Yo, get away from me, buddy.
No, dude, who are you?
Away from me, dude.
Why are you here?
Back the
Why are you here?
I suggest you leave me alone.
You're on private property.
I suggest you do something about that then and get back inside.
Ooh. Really?
Yeah, really. You like going around people like this?
You know
think
what?
that's fun? Don't touch my buddy.
Oh, go ahead. Oh, so
Do it. Do it.
What
Touch it. That's on camera. Back the
are we doing here?
back the off, buddy. You touch, you get tased. Get the back inside.
What's going on here?
Why did he come up and grab me?
You back off.
Yeah, you did. Yeah, you did, buddy.
Get that thing out of my face.
No, you can come up to me, get in my face. I'll do something, buddy. Get
I'll
inside.
call 911.
Get inside.
Call the sheriff's department. Whoa, dude.
Whoa, dude, you just come up and grab people? The is
Did I
wrong with
grab
you?
you?
Your homie did.
Don't hate my homie. This is private property. You say you're filming.
This is an easement. I'm not on your property. You see that? That belongs to the city.
And why are you?
Mr. Roberts informed the workers that he was on an easement and not on private property since the utility poles on the premises are owned by the city. Florence County's Geographic Information System, GIS data, indicates that Mr. Roberts was indeed on public property. It is crucial to understand that the presence of government-owned utility poles on a property does not automatically make the entire property accessible to the public. In certain cases, the government may secure a utility easement, permitting the placement of utility poles on private land without transferring ownership or changing the property's private status. Therefore, contrary to a common misunderstanding within the auditor community, the mere location of utility poles cannot reliably determine whether someone is on public property.
Let me ask you a question. Does that give you the right to come up and grab my camera and almost break it?
Hey,
You assaulted me, buddy.
Call 911.
call the sheriff's department.
Hey, call your husband.
Yeah, call your husband, fat boy.
Man, whoa, this guy's great.
Get in, Tubby. I'm out in public recording, and you come up and grab somebody, dude. I'm with myself. And you're about to owe me a new camera lens. Yeah, buddy, I got your name too. You're gonna get a nice little talking to with the police. You come back out here and touch me, you won't like it.
What's going on, bud?
Oh, nothing, just getting assaulted out here, that's about it.
Getting assaulted.
Yeah, by one of their workers.
What happened?
I was just out here taking some pictures, and one of the guys came out here saying he didn't want to be filmed, and he ran up to me, started circling me, grabbed my camera, started pushing up on me, and it's all videotaped.
You have it on video?
Oh, it's all recorded. Because I do want to press charges on him.
Was there something involving a taser?
Oh, I pulled it out in self-defense.
Okay.
When you come out at me like that and you're about to destroy my stuff and do bodily harm to me, you're damn right I'm gonna pull a taser on someone.
Mr. Roberts contended that one of the workers assaulted him by seizing his camera and pushing him, leading him to use his taser in self-defense to protect himself and his equipment. According to Section 16-3-600 of the South Carolina Code, a person commits the offense of assault and battery in the third degree if the person unlawfully injures another person or offers or attempts to injure another person with the present ability to do so. The South Carolina Court of Appeals clarified in the 2022 case of State v. Robinson, "Our jurisprudence has never required an actual physical injury to a victim's person to constitute an assault and battery, and there's no requirement that a victim is physically harmed or violently injured." Similarly, the Fourth Circuit Court of Appeals, which oversees South Carolina, stated in the 2019 case of United States v. Drummond, "A violent injury for the purposes of an assault conviction requires no violence, as is commonly understood, or a threat of physical harm, or injury at all. Rather, an assault encompasses any touching of the person or an individual in a rude or angry manner without justification." Given this broad interpretation of what constitutes assault, a court could easily determine that the worker's push was sufficiently offensive to warrant a third-degree assault conviction. Additionally, under Section 1611.510 of the South Carolina Code, it is unlawful for a person to willfully and maliciously injure or destroy any kind, class, article, or description of personal property or the goods and chattels of another. This statute requires that the state prove the individual acted with a willful and malicious intent to sustain a conviction. As defined by Black's Law Dictionary, willful means voluntary and intentional, but not necessarily malicious, and malicious means substantially certain to cause injury, or without just cause or excuse. It could be argued that the worker intended to harm Mr. Roberts by grabbing his camera, justifying a conviction under Section 1611.510. However, the footage does not clearly show whether the camera was damaged, and it was not destroyed since Mr. Roberts continued filming.
You need to tell that guy he needs to not put hands on people. It's a short little fat guy.
I'm gonna address it. Okay?
Oh yeah, we're gonna do a report on him too.
That's fine. I just need to give this deputy your information for me, all right? You have an ID or something?
I don't have an ID. Yeah, buddy, you're gonna learn you can't come outside and grab people, man. That ain't right.
While we're handling this, don't yell. You're just
All right.
cause him to get up.
Is it free speech? Am I allowed to say stuff?
Well, you have a freedom of speech, but there's also something called breach of peace.
Okay, I'd like to see you try that, buddy. Those people put hands on me. I'm the victim. So you want to turn it around on me?
I'm not turning it around.
Please do so.
What I'm telling you is...
You guys are known to be the biggest pieces
Okay.
in South Carolina. What did I do wrong?
Are you going to let me talk?
Go on ahead.
What I was saying is, I don't need you yelling while I'm trying to talk to this man, because that's going to cause him to yell, cause a scene. You get mad, he's going to get mad, then it escalates.
Okay.
Just talk to this deputy.
Let me tell you something. I'm allowed to say whatever the hell I want.
If you yell across this parking lot while you have all these people standing around, that is called breach of peace.
You want to try that,
I
buddy?
will lock you up for
You
that.
want to try that?
2 deputies from the Florence County Sheriff's Office responded to the worker's call. During their investigation, one deputy claimed that if Mr. Roberts shouted at the workers across the parking lot, he would be arrested for breach of peace. In South Carolina, breach of peace is a common law offense, meaning it is governed by case law rather than statute. The South Carolina Court of Appeals in the 1996 case of State v. Pierre explained, "The term breach of the peace is a generic one embracing a great variety of conduct, destroying or menacing public order and tranquility in general terms. It is a violation of public order, a disturbance of the public tranquility by any act or conduct inciting to violence." The court further clarified, although it includes acts likely to produce violence in others, actual violence is not an element of breach of peace, and whether conduct constitutes a breach of the peace depends on the time, place, and nearness of other persons. Similarly, Section 16-17-530 of the South Carolina Code, defining disorderly conduct, states, "Any person who shall be found at any public place conducting himself in a disorderly or boisterous manner, or who uses obscene or profane language on any highway, or at any public place or gathering, or in hearing distance of any schoolhouse or church, shall be deemed guilty of a misdemeanor." While Mr. Roberts' yelling across the parking lot might initially seem to fall under breach of peace or disorderly conduct, the Supreme Court ruled in the 1964 case of Henry v. City of Rock Hill, The 14th Amendment does not permit a state to make criminal the peaceful expression of unpopular views, and the government cannot define a criminal offense so as to permit conviction if an individual's speech stirs people to anger, invites public dispute, or brings about a condition of unrest. However, the South Carolina Court of Appeals in the 2002 case of City of Landrum versus Surratt held that an individual could be convicted of disorderly conduct for loudly using profanities and name-calling, as these remarks, combined with the loud delivery, constituted fighting words under the Supreme Court's fighting words doctrine from the 1942 case of Chaplinsky versus New Hampshire. Fighting words, or words that by their very utterance inflict injury or tend to incite an immediate breach of the peace, are not afforded the protection of the First Amendment and therefore can be criminalized. Although Mr. Roberts did use profanity during his interactions with the workers and deputies, he did not use any profanity when shouting across the parking lot. Even if he had, it is unlikely a court would find that his comments incited an average person to violence. Therefore, a court would probably determine that Mr. Roberts' actions did not amount to breach of peace or disorderly conduct, as his speech was protected by the First Amendment.
Try it. Try it. Name and badge number.
Corporal Driggers, 108.
Name and badge number.
Driggers, 236.
All right, go do my assault charge.
I need you to give him your
You
information.
need to go talk to them. And you better file charges if I'm giving you my information.
What's your day, bro?
If you don't, believe me, you guys will get complaints, and this will be all over you.
Whatever you need to do, man.
They have to run me first, everyone. They can't run the actual criminal. Can you go tell them, go question the guy who assaulted me?
He's gonna conduct his investigation. Do you see him up there?
No, he's not. He's inside hiding.
What was he wearing?
He had a blue shirt. Short, dark hair, fat. So what was the call about?
Somebody coming up here, harassing employees and pulling a taser on someone.
They tell you they circled me and surrounded me? The part where they assaulted me, they forgot, they left that out.
Hi, Mr. Roberts. I spoke with the two gentlemen that came out, and all their information is going to be entered into the report as well as your statement you gave this deputy. I made them aware that yes, you can view video from a public area, which the roadway is public. But if you cross over into the
I've checked the property lines. I don't need directives.
you go on the property, you're going to go to jail.
If you smoke crack, that's not good, man. All right, do I get a report or something?
You're going to get you an hour.
Oh, great, this guy.
Here you go, buddy.
All right, my name, badge number beside it, and your case number as well. You can get a copy of the report, 35 business days. Have a good day.
Thank you. See how the cop tried to spin it and say I was in their parking lot?
How you doing, sir? How you doing, sir?
Not too good.
Wow, what's going on today, buddy?
I had some dude inside. Oh, you're getting really close, man.
Oh, yeah, I like to get close. I like to talk to people.
Can you stop?
No, sir.
so
I want to
close?
talk to you. What's going on, my
stop,
friend?
Stop getting so close to me, dude.
What's going on, man?
Dude, stop approaching me.
Sir, I'm allowed.
Back off, dude. Give me some space, dude.
Go ahead and turn.
Give me some space,
your hands
dude.
behind your back.
No, give me some. Ow! Oh.
Behind your back.
What? For what? For you?
Absolutely.
Oh yeah, very nice, dude. Very nice. Enjoy the lawsuit. Enjoy paying for my camera too.
Absolutely. You getting resisting arrest?
Resisting, I'm not moving.
Nope. When I went to put my hands on you, you pulled away from me.
Yeah, because you have no right to arrest me. I
Sir,
did
you're
nothing.
under arrest. You have the right. The attorney
You
have
kept
him or a present.
approaching me.
Sir, you have the right. The attorney have him or present before any questions asked. You decide any time to exercise these rights and not make any more statement. Do you understand these rights?
I don't answer any more questions without a lawyer present.
Absolutely. All right, go on.
Sergeant Paul Morrison responded to the scene and approached Mr. Roberts, who repeatedly asked him to maintain some distance and attempted to step away. When Mr. Roberts directed profanity at him, Sergeant Morrison tackled him to the ground and claimed he was under arrest for resisting because Mr. Roberts pulled away. Mr. Roberts argued that Sergeant Morrison had no right to arrest him under Section 16-9-320 of the South Carolina Code. It is unlawful for a person knowingly and willfully to resist an arrest being made by one whom the person knows or reasonably should know is a law enforcement officer. While resisting arrest nonviolently can lead to conviction, if Sergeant Morrison was attempting to arrest Mr. Roberts, he did not inform him of his intentions or take any steps to notify Mr. Roberts that he was being placed under arrest. Consequently, a court would likely rule that Mr. Roberts could not be convicted of knowingly and willfully resisting an arrest. Additionally, Sergeant Morrison lacked a lawful basis to arrest Mr. Roberts when he approached him. South Carolina law has long held that individuals are not obligated to comply with unlawful arrests and have the right to resist them. The South Carolina Supreme Court summarized this in the 2001 case of State v. McGowan. An unlawful arrest or an attempt to make an unlawful arrest stands upon the same footing as any other non-felonious assault or as a common assault and battery. The person who is so unlawfully arrested or against whom such an unlawful attempt is directed is not bound to yield and may resist force with force, but he is not authorized to go beyond the line of force proportionate to the character of the assault, or he in turn becomes a wrongdoer. It's important to note that this case law is specific to South Carolina, and many states do not recognize a citizen's right to resist an unlawful arrest. However, in this case, Mr. Roberts had the right to resist an unlawful arrest, and since he did not use any physical force when stepping away from Sergeant Morrison, there was no issue of disproportionate resistance if a court found that he was resisting an unlawful arrest.
Got a taser, so.
Oh yeah, I got assaulted.
So here's the thing, you pulled it out and you was threatening him.
He attacked me. It's on camera.
All right. Well, we're gonna log all this in too.
Dude.
After Sergeant Morrison arrested Mr. Roberts, he was taken to jail and booked. However, no criminal charges were filed against Mr. Roberts. Following his release, he submitted a formal complaint to the Florence County Sheriff's Office. This complaint led to an internal affairs investigation, and internal records show that Sergeant Morrison resigned on September 15, 2022. Sheriff T.J. Joy released a statement regarding the incident saying, "The internal affairs investigation determined numerous FCSO policy violations during the incident. As a result of the investigation, Sergeant Morrison is no longer employed by the Florence County Sheriff's Office." Sheriff Joy also mentioned, "The matter has been referred to the 12th Circuit Solicitor's Office, but as of the date of this episode, no criminal charges have been initiated against Sergeant Morrison." Additionally, Mr. Roberts claimed that after the incident, Sergeant Morrison deleted the video footage of their encounter from his camera. Fortunately, Mr. Roberts was able to recover the footage and upload it to YouTube, along with a brief video that appears to have been recorded in the police cruiser after his arrest, which Mr. Roberts alleges Sergeant Morrison took while deleting the videos. The Florence County Sheriff's Office has not specifically addressed the issue of the deleted videos in any public statements. Overall, Sergeant Morrison receives an F for unlawfully arresting Mr. Roberts without probable cause, using unnecessary force, conducting the illegal arrest, and attempting to cover his actions by deleting Mr. Roberts' video footage of the encounter. While Sergeant Morrison claimed he was arresting Mr. Roberts for resisting arrest, he had no valid reason to do so initially. It appears clear that he arrested Mr. Roberts for refusing to comply with his arbitrary displays of authority. This type of police behavior is not only entirely unacceptable, but also dangerous. I commend the Florence County Sheriff's Office for promptly investigating and addressing the situation, though I question the department's decision to allow Sergeant Morrison to resign rather than terminate him. The other Florence County deputies receive a C because, although one threatened to arrest Mr. Roberts for breach of the peace in a situation that likely would not support such a conviction, they ultimately affirmed Mr. Roberts' right to film in public and educated the workers about his First Amendment rights. While they seemed annoyed with Mr. Roberts and occasionally responded unprofessionally to his antagonistic remarks, they ultimately made the right decision and supported his right to film. Mr. Roberts receives a B+ because, although his aggressive and antagonistic behavior toward the workers and officers did not help the situation, and he misunderstood the nature of utility easements, he remained within his First Amendment rights throughout the encounter and consistently stood up to officers attempting to infringe upon his First and Fourth Amendment rights. However, his mean-spirited comments about the workers' appearances were immature and, in my view, undermined his credibility as a professional and respectable auditor. Next, shortly before 11 p.m. on May 30th, 2021, officers Nicholas Hanning and Ellie Summers from the Idaho Springs Police Department in Idaho Springs, Colorado, responded to a 911 call made by Timothy Braden and his roommate Brittany Odom, who had recently moved into a new apartment complex. They claimed that their new neighbor, 75-year-old Michael Clark, had struck Ms. Odom in the face following a noise disagreement. The officers arrived at the apartment building and knocked on the door of Mr. Braden and Ms. Odometer.
No. I'm here. I'm Tim. This is Brittany. That was the neighbor right there. We're the ones that called. Wait. This is Brittany. She's the one that got hit. I live here. This is my friend Brittany. And then this is my neighbor that hit her. I wasn't even here. I was outside. I literally just saw you.
He banged on the door, or through the wall. Bam, 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 and I'm sleeping. Shut the up. And so I came out and was like, what's going on? He busted all of my shit. My nose, my mouth. All I wanted to do was hey, what was disturbing you? And he was like, shut the fuck up. Boom.
Is he white, black?
He's
Hispanic?
white.
Does he have hair?
Yeah.
Bald?
Gray hair?
Yeah, gray hair. He's an older guy. He's about this tall. That guy lives right there in that room. And that's where the wall would go.
He was bang, bang, bang. That's what woke me up.
We just moved here yesterday, but I saw him last night or night before.
Okay.
After a brief conversation with Ms. Odom, the officers left and proceeded to knock on Mr. Clark's door. Throughout her interaction with the officers, Ms. Odom appeared visibly intoxicated, and there was no tangible evidence supporting the injuries she alleged. Furthermore, if the officers had requested a background check, they would have found that Ms. Odom had an extensive criminal history, including a 2016 first-degree fraud conviction for providing a false identity to police, multiple felony domestic violence charges, and a DUI conviction with a .15 BAC resulting in property damage. Regarding the so-called knock-and-talk doctrine, officers generally have the authority to knock on a residence and ask questions without needing a warrant, probable cause, or reasonable suspicion. The Supreme Court outlined this doctrine in the 2013 case of Florida v. Jardine, stating, "We have recognized that the knocker on the front door is treated as an invitation or license to attempt an entry. This implicit license typically permits the visitor to approach the home by the front path, knock, promptly wait briefly to be received, and then, absent invitation to linger longer, leave accordingly." The court concluded, a police officer not armed with a warrant may approach a home and knock precisely because that is no more than any private citizen might do. However, while a court would almost certainly agree that the officers could knock on Mr. Clark's door to attempt a conversation, it is much less probable that a court would find they had sufficient grounds to arrest him. In the 2007 case of Cortez v. McCauley, the 10th Circuit Court of Appeals, which oversees Colorado, explained, "A warrantless arrest is permissible when an officer has probable cause to believe that a person committed a crime. Probable cause to arrest exists only when the facts and circumstances within the officer's knowledge, and of which they have reasonably trustworthy information, are sufficient in themselves for a warrant. A man of reasonable caution, in the belief that an offense has been or is being committed." The court further clarified, "In evaluating whether the events leading up to this arrest amount to probable cause, we ask whether an objectively reasonable officer could conclude that the historical facts at the time of the arrest amount to probable cause. Probable cause is based on the totality of the circumstances and requires reasonably trustworthy information that would lead a reasonable officer to believe that a person about to be arrested has committed or is about to commit a crime. Likewise, the court indicated that a police officer may not close her or his eyes to facts that would help clarify the circumstances of an arrest. Reasonable avenues of investigation must be pursued, especially when it is unclear whether a crime had even taken place. In this case, since Ms. Odom was heavily intoxicated, she was at best an unreliable witness. There was no physical proof that she had been assaulted, and her criminal background involved intoxication, violence, and deceit towards the police. A court would likely determine that a reasonable officer would not believe there was probable cause to arrest Mr. Clark based solely on Ms. Odom's unsupported accusation.
I'm gonna put my dog in the bathroom, okay?
Okay.
What do you want?
Put it down!
Put it down!
Put it down!
Get on the ground now!
Get out here right now! Get out here!
Get on the ground!
No. They hit that wall so hard, I thought they were going to come through the wall.
When the officers knocked on Mr. Clark's door without identifying themselves as police, Mr. Clark answered holding a collectible sawfish snout sword, crafted from a sawfish's bill. In a subsequent statement, he explained that he believed they were his neighbors and grabbed the sword in case he needed to defend himself. Upon opening the door, Officer Hanning entered the apartment, appeared to push Mr. Clark, and demanded that he put down the sword. Mr. Clark immediately complied, placing the sword back on a bookshelf. However, when Officer Hanning instructed Mr. Clark to exit the apartment, while Officer Summers simultaneously told him to lie down, Mr. Clark refused both commands. Officer Hanning then promptly deployed his taser without any warning. Upon being tasered, Mr. Clark collapsed, struck his head on a dining chair, and lost consciousness. Before evaluating the legality of Officer Hanning's use of the taser, it's important to recognize that Colorado law does not forbid an individual from openly carrying a sword of any length in both public and private spaces. Additionally, while Section 18-12-105 of the Colorado Revised Statutes prohibits concealing a sword with a blade longer than 3.5 inches, the statute clearly states, "It shall not be an offense if the defendant was in his own dwelling at the time of the act of carrying." Therefore, Mr. Clark was undoubtedly within his rights to answer the door while holding the sword. According to Idaho Springs Police Department Policy Number 304, the taser device is intended to control a violent or potentially violent individual while minimizing the risk of serious injury. The taser device may be used in any of the following circumstances: when the circumstances perceived by the officer at the time indicate that such application is reasonably necessary to control a person. The subject is violent or is physically resisting. The subject has demonstrated by words or action an intention to be violent or to physically resist, and reasonably appears to present the potential to harm officers, himself, or others. Additionally, the taser policy specifies that using the taser on certain individuals, including the elderly and obvious juveniles, should generally be avoided unless the totality of the circumstances indicates that other available options reasonably appear ineffective or would present a greater danger to the officer, the subject, or others, and the officer reasonably believes that the need to control the individual outweighs the risk of using the device. The policy also mandates that a verbal warning of the intended use of the taser device should precede its application, unless it would otherwise endanger the safety of officers or when it is not practicable due to the circumstances. The continuation states, if after a verbal warning, an individual is unwilling to voluntarily comply with the officer's lawful orders and it appears both reasonable and feasible under the circumstances, per Section 18-1-707 of the Colorado Revised Statutes, peace officers in carrying out their duties shall apply non-violent means when possible before resorting to the use of physical force. A peace officer may use physical force only if non-violent means would be ineffective in effecting an arrest, preventing an escape, or preventing an imminent threat of injury to the peace officer or another person. Similarly, Section 18-8-803 of the revised statute states, "A peace officer who uses excessive force in the pursuit of such officer's law enforcement duties shall be subject to the criminal laws of this state to the same degree as any other citizen." Officer Hanning's choice to activate his taser in this scenario clearly violated multiple aspects of this policy, as Mr. Clark was an elderly individual who was neither violent nor had he indicated any intent to harm anyone. He merely refused to comply with contradictory orders while standing calmly in his own home. Officer Hanning then used his taser without the necessary warning. A court would likely view this as excessive force under Colorado law, given that Mr. Clark was not being arrested at the time the taser was used, and there was no indication he was trying to escape or injure anyone. Even if there had been such intentions, Mr. Clark did not demonstrate that non-violent methods would be inadequate for arresting him or preventing an escape.
Party's unconscious. Sir? 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 Sir, talk to us. Talk to me. Talk to me. Sir, talk to me.
That big bat that he's holding, that looks like a freaking...
Where did you find that? Did you have to hunt for it?
It was laying right there on the ground when I walked in. All right.
I did not get that down.
Not arguing with you.
I did not get that down.
All right. We're gonna sit up.
I did not get that down.
I'm gonna go down with you.
It was on.
You want him out of
up
cuffs
there.
up here? Okay.
Did you go in my apartment and look for weapons?
Mr. Clark, you're gonna sit up.
Did you look in my apartment and look for weapons?
We don't need. They don't need to look out in the apartment. It was here in the hallway.
How did they get in the hall?
After Mr. Clark lost consciousness, the officers failed to call for medical help. Instead, they dragged his unconscious body into the hallway. Later, after summoning EMTs, Officer Hanning took Mr. Clark's sword from the top of the bookshelf in his apartment and placed it in the hallway. Although they never explicitly admitted to it, the officers seemed to be staging a crime scene to portray Mr. Clark as attacking them with the sword when the taser was used. According to Section 18-8-610, a person commits tampering with physical evidence if, believing that an official proceeding is pending or about to be instituted and acting without legal right or authority, he knowingly makes, presents, or offers any false or altered physical evidence with intent that it be introduced in the pending or prospective official proceeding. While there is limited case law interpreting the statute, it is evident that the officers moved Mr. Clark and the sword to make him appear as a violent threat, knowing that an investigation into their use of force was likely, and that Officer Hanning could face criminal charges for excessive force. Therefore, it is highly possible that the officers could be convicted of tampering with evidence under this statute.
What is going on? I've done nothing wrong. What did I do?
What's that?
What did I do?
Punch that girl.
Huh?
Punch that girl, then answer
No,
the door with a freaking machete, man.
Oh, no, that is absolutely false.
All right.
Okay.
We're gonna stand here on.
I did not come after nobody.
Okay. You're dealing with me now. We're gonna go down to the ambulance so I can.
I was just in bed.
All right. We're gonna stand up on the count of three. Ready? 1, 2, 3. Stand up.
I attacked nobody. I did nothing.
Does this look familiar?
I messed up my top.
Just sit.
I did not come at anybody.
Sit down.
Swing your legs up. Swing your legs up. Sir, swing your legs up. Feet, please. Go straight.
Mr. Clark was immediately transported to a hospital and, despite the officer's threats, was never criminally charged. A toxicology screen revealed no alcohol or illegal substances in his system. On June 1, 2021, 2 days after being tasered, Mr. Clark suffered a stroke while still hospitalized. As of the date of this episode, he remains unable to care for himself and requires 24-hour supervision and assistance. In July 2021, Officer Hanning was charged with assault in the third degree against an at-risk person, a Class 6 felony, and was dismissed from the Idaho Springs Police Department. He pled guilty to the charge in January 2022 and received a sentence of 2 years probation, 120 days of electronic home monitoring, and 150 hours of community service. He was not charged with any crimes related to the apparent cover-up attempt after tasering Mr. Clark. Officer Summers resigned from the Idaho Springs Police Department in October 2021, but was not charged with any offenses. In July 2021, Mr. Clark filed a federal lawsuit against the Idaho Springs Police Department, and on November 2, 2022, his attorney announced that the lawsuit had been settled for $7 million. However, the city stated that the settlement was not an admission of liability and was made for economic reasons and to bring closure to all involved. Overall, former officers Hanning and Summers receive an F for employing unnecessary and excessive force against an elderly man, delaying medical treatment by moving his unconscious body, and tampering with the crime scene to make their actions appear justified. While I generally aim to give the benefit of the doubt to those involved in the interactions we examine on this channel, the officer's intentions in this encounter are clear. Officer Hanning tasered Mr. Clark because he refused to comply, and the officers moved Mr. Clark's unconscious body and the sword to the hallway to suggest he had physically threatened them. There is no plausible alternative explanation. These officers' actions rank among the most reprehensible we have ever reviewed, and if it were possible to assign a lower grade than an F, I certainly would. As for Mr. Clark, I cannot justly assign a grade to someone who was simply the victim of false accusations, excessive force, and police misconduct. While I am pleased that his lawsuit was settled for a substantial amount, I recognize that no sum of money can fully compensate for the irreversible damage to Mr. Clark's health and mental state. I wish him and his family all the best and hope that this well-deserved settlement will at least enable Mr. Clark to receive the necessary care. Thanks for watching US Corrupt Cops. If you found this video insightful, don't forget to subscribe and hit the notification bell so you never miss an update. Share your thoughts and experiences in the comments below. We love hearing from you. Stay tuned for more real-life stories of justice and retribution. See you next time.